I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it at the time it was.
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text of the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator,
but first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several fundamental amendments to the...
But isn't that inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean with those... Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which have...
But do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial equality.
You're not answering my question. I'm trying to understand how you think. It's very easy to say, we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute...
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No. I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say, I would use the same approach essentially in all cases, regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point...
I'm going to run out of time. With respect, answer my question.
Well,
okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
why don't you just look at legislative history?
Well, you can't look at legislative history statements one by one because the individual intent... Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the law doesn't matter.
This will be my last question. I'm sorry. Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic, it's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that has interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Or what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems
Yes,
in
sir.
America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use, notice or fact?
No, fact.
Okay. Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a reconstruction.
Can you turn your microphone on, please?
Sorry
Thank
about
you.
that. I believe the Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported that and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
If you interpret the Constitution by looking at its public meaning at the time.
separate was not, it was inherently unequal, not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that
time
case-
the Constitution was passed?
I'm talking about right now. I believe that it's good
No,
law,
but
Senator.
okay. I've gone way, way over. I'm sorry, Counselor, I didn't get to you.
No problem, Senator.